welcome everybody. Today is 7th of May. We are discussing regulatory enforcement. This is part two, the response, with Elizabeth Lees and Mark Burrows of Claritas Legal in the Cayman Islands. And I want to welcome our audience. I want to welcome all of you who watch us regularly and those who are just listening in from your phones. Welcome again to our AML Gray Matters broadcast. A little bit of housekeeping before we do get started. This is just a reminder. This is training and informational purposes only, not legal advice. If you do want proper legal advice, Elizabeth and Mark, I'm sure will be happy to help you. And of course, their website and emails will be posted at the end. We do try to end at approximately 1 hour. Sometimes we do go over a little bit, but we do try to get through the heart of the topic in 1 hour. There is a certificate of attendance that will be automatically generated and sent to all attendees of today's live broadcast. And you'll get those in your inbox in about 1 hour after the end of the broadcast. I think we'll post questions at the end, but there is a question box. You are welcome to post your questions. And I will let Elizabeth and Mark kind of proceed on with their presentation, and then we'll just ask the questions at the end. Is that okay, Elizabeth? Do you agree with that process?
Yes, sounds great.
Perfect. And of course, the silocompliance.com website, that's where you can go to get the AML Gray Matters. You can see upcoming webinars, previous recordings, and also sign up to stay informed. All right, I'm going to let you guys get kicked off. If you want to turn off your cameras now so that you can let the audience focus on the slides, and I will let you kick off. And thank you again for doing this for us, Elizabeth.
Thanks so much for having me, Kimberly, and thanks for having me back again for part two of our two-part series. So as we were saying just before 10 o'clock, last time we looked at the various powers available to the regulators in terms of the enforcement toolkit that they have. And we looked at that both in terms of CIMA as our regulator of our financial institutions, as well as for our other regulators in the Cayman Islands. So that was part one. And this week it's part two, which is the response. So we're going to have a look at initial responses. So this is pre-court remediation, which we'll see is really important. Some of the wider consequences to take into account. And we'll also look briefly at criminal prosecution. And those who were here last week, we looked at that as partly one of the regulatory toolkit measures that may be imposed, for example, for breaching the anti-money laundering regulations, as well as for those specific offences, such as failing to file a suspicious activity report. Then I will hand over to Mark, who will be looking at the court proceedings. So Mark's background is in commercial litigation and particularly in the financial services division in the Grand Court of the Cayman Islands, and you'll be hearing about regulatory appeals there. So he'll be looking at judicial review or statutory appeal routes, other considerations such as a stay, extensions of time, confidentiality, the cost of these matters, and of course the ongoing need to attempt to settle. We'll also look at some of the recent cases that are public in the Cayman Islands, and then we'll finish off with a quick conclusion to sum up what we have gone over.
Great. And Tom, do you mind launching that very first poll question? Because we did want to ask the audience a quick poll question. And this is just regarding the training, just to see if who here has had any kind of regulatory enforcement training. Whether it's for, and of course the impact that might have on individuals and directors. So just so we kind of get an idea of what our audience. Okay, can you see the responses, Elizabeth?
Yes, I see about 50%, roughly half of the audience has had training on regulatory enforcement options. So about half haven't and just a few say it's not applicable. So about half
Okay.
have and half haven't. So I hope even for those who have, we'll be going into a little bit more detail today than may have
Okay.
previously been covered.
Great, great. And so this is should be very useful for those who have not had it as well. Great. Okay, we could end that poll. So yeah, so about 50-50. Thank you for participating in that. Okay, we'll continue on.
So we said, first of all, we'd look at the initial responses. One item to consider is whether the statute itself allows for a response. For example, under the Bank and Trust Companies Act, it specifically stated that if you get a notice of revocation, you have 7 days to apply for reconsideration. So that is one option to always consider, although it is a fairly limited one. The more common ones are either an enforcement notice by way of a warning notice that enforcement action will be taken, or a breach notice in terms of administrative fines. And both of these notices contain options to make representations. So we're going to look at each of those in a bit more detail, starting with the warning notice. So CIMA does have an enforcement manual, and the enforcement manual is public. And we talked last time about the transparent nature of these matters and the enforcement action and the consideration, and the fact that all of this information is publicly available. So the purpose of the warning notice is to give a reasonable opportunity for the parties who are affected by these enforcement decisions to make representations to the authority prior to the final decision. So this is applicable in matters which are not the fine matters. So I'll come on to the fine matters separately. But this is in relation to enforcement actions such as a suspension of your license or your registration, a revocation of that license, where the authority adds conditions to your license or requires the substitution, for example, of a director, or requires other action to be taken by the licensee. So in these scenarios that we looked at last time, you may find yourself subject to a warning notice for a breach. Now, we should just note here that, of course, there may be urgent situations. For example, financial crime is one of the examples given. And in those circumstances, it may not be possible or feasible to go through this procedure, warning notice, decision notice. But this is the normal procedure, excluding those circumstances. So the warning notice will be a notice in writing stating the action that the authority proposes to take and the reasons for the action. It will also contain a statement that the affected party may make representations within a specified period and the contact to whom those representations may be made. Now, it will contain the reasons. Again, just a side note, there may be exceptional circumstances where the authority is not able to disclose full reasons. For example, confidential information received from another regulatory authority. But again, these are limited. So we're talking about the usual procedure here. So a warning notice with the reasons and with the length of the representation period. In considering that period that you will have to make your representations, the authority will consider how complex this case is, what the action is, and the risk to the stakeholders and the financial system. Now, if the affected party thinks that this warning notice response period is too short, there may be a request for more time, which the authority will consider. And the enforcement manual says that there may be an extension of up to 14 days. So once your written representations have been sent to the authority, and we'll talk a little bit more about the considerations that will go into this, but the authority will then have two options. The authority may take the view that no further action is needed, and then it will notify the relevant parties of the decision not to proceed, or it may decide that the action does require further action, and then a decision notice is issued. So we'll be looking at the procedure that will be followed if a decision notice is decided upon. So it's important to note here, as we said last time, that CIMA makes it clear that the procedure should be transparent, proportionate, and fair. Before we come on to some of the considerations that will be taken into account in exercising this in a proportionate manner, we did have another poll, which was about whether any of our listeners had been part of a remediation project. And perhaps we'll come on to that after this slide, Kimberly, because this slide explains the considerations that CIMA will take into account when considering the enforcement action. And I think what's really important to note here is the willingness and ability of the party to cooperate with and assist the authority. So this includes how quickly the matter was brought to the attention of the authority, and we'll come on to various discounts that may be granted in that regard, how timely the responses were to requests of the authority, and crucially, any remedial action that the party has taken already or intends to take in rectifying the situation. So these are all considerations that will be taken into account, as well as, of course, the nature and extent of the contravention and the extent that remedial action will rectify the contravention, as well as previous compliance history. So on that note, Kimberly, if we could move to the poll, which is about whether any of the listeners have been part of a remediation project based on regulatory findings.
Okay, great. Tom's launched the poll now. Says, have you participated in any remediation projects initiated due to a regulatory finding? I've given several options here. So yes, frequently, like you've done it multiple times, maybe at different employers. Some of you have done it just maybe 1 or 2 times. Some not at all, but maybe your company has. Maybe you just not personally participated. And then another option is that you've not been involved or your company has not been involved. And those of you who are, of course, not applicable or are not sure. So yeah, so right now we're showing about 35% are saying yes, occasionally 1 or 2 projects, remediation projects. Just over 10% are saying frequently multiple projects, remediation projects. Okay. Yeah, and just for those of you who might not be familiar with the term remediation, it's just when you're having to go back and fix the files and make sure you're basically going back into existing clients and getting everything. It's not a periodic review as much as just making sure you have everything in place. Is that how you would describe it, Elizabeth?
Yes, I think when you
Yeah.
receive a finding notice from the authority, usually following an inspection, and then you are required to remediate certain actions or requirements that were found not to have been met. And
Mm-hmm.
it's interesting that I think we see here about 50% have either done this once or more, and then another 15% on top of that have had their company be subject to remediation projects. So I think quite a large proportion of the listeners have been involved in a remediation project directly or indirectly, which is interesting, and I think it shows it's quite a frequent
Mm-hmm.
occurrence where remediation is needed.
Right. Okay. I don't
So
know
we
if
will
Tom shared that, but we can close that poll and move on. But yeah, it was yeah, about 50% have done this a few times. Okay.
so
Thank
we
you.
looked here that those remediation projects will of course be important to CIMA when considering whether or not to take this enforcement action. As well as those general considerations that we see here, there are also in the enforcement manual sections for each type of enforcement action. So I've just pulled up one example here, which is the example of the revocation of the license or the cancellation of the registration, as the case may be. And you'll see here that, again, specific criteria are listed, including and always not limited to the seriousness of the breach, the extent of loss, the extent at which the stakeholders' assets appear to be at risk, the financial resources of the party, any contagion risks, the party's financial position, and, important in the case of a revocation, any alternative solutions that may be available. So the enforcement manual general criteria, and for each type of enforcement action, it lists the application, who it's applicable to, the purpose, the criteria, as you can see here for one example, and some details of the implementation of that action. So that is a useful resource. So we have general criteria, and then we have specific criteria for each type of action. Those criteria will, of course, be taken into account by your lawyer when making those representations in response to any warning notice that is issued for those types of enforcement action. Now, the other type of enforcement action is, of course, the administrative fines. And we looked last time of the powers of CIMA and the other regulators in this regard. And we noted that for individuals, and we talked about the amendment to make sure it was very clear that this was applicable to directors and other senior officers and managers. For those individuals, the fine amounts, the maximum fine amounts remain the same, whichever supervisory authority issues them. In relation to the serious and very serious breaches for entities, and again, we said entities was also extended. It includes partnerships, LLPs, etc. For those, the fine amount varies. So up to 1 million for CIMA and 250,000 for the other regulators for a very serious breach. And again, we said this is one individual breach. So of course there could be more than one breach at any given time. So when the authority becomes aware of a breach, and before it gets to this stage of issuing this fine, what does it do? So that's what we see on the next slide. So we talked about the enforcement manual. Another aspect of the enforcement manual is the procedure for administering administrative fines. And that procedure can be found on the website again, and it is stated to be part of the enforcement manual. There are also the Monetary Authority admin fine regulations made under the Monetary Authority Act. And then there's the procedure, which gives more information on how this is carried out. So you can see here that an investigation team will be appointed. That investigation team will produce a report for the managing director, now the CEO, who will then form an oversight committee. That oversight committee will determine whether there's sufficient evidence to issue a breach notice. That's a notice indicating that the authority is of the view that you will be subject to a fine. And again, you have the opportunity to make written representations. Those representations will go back to the Oversight Committee, and the Oversight Committee, along with the Compliance Division, may decide that that's sufficient and no further action is required. Alternatively, they may decide that a fine is recommended, at which case it will go to the Management Committee. The Management Committee may decide that a fine is required. However, if that fine is more than $500,000, it goes to another committee, which is the Executive Committee, and then the fine may be issued if the criteria are met. So I think it's important to note here there are a number of stages, a number of checks and balances before we reach that stage of issuing the fine. So if we just have a look at some of those in a little bit more detail, starting with investigating the breach. So the authority has a wide range of statutory powers. In relation to these particular investigations, the authority may use an investigation letter. And again, the relevant party will be allowed to make representations on the matters outlined in that letter. We already noted the fact that the authority will take into account the cooperation with the authority. So these investigation letters, again, it's important to take them into account, to respond as best as possible. And it's noted that the authority will take into account whether you have failed to respond, and this may be an aggravating factor, and actually it may also give rise to enforcement action or an additional fine. So regulatory investigation letters may come, you will respond, and there may be more such letters. Secondly, if we look at the Oversight Committee, the Oversight Committee is put together to look at the evidence that was gathered during that investigation and to decide whether evidence is sufficient to prove that the alleged breach occurred. Again, it may require further information or evidence. Then it can make a recommendation based on the criteria that we'll come on to, and also considering any discount agreement, which we'll also come on to. That Oversight Committee will consider representations made and will also be in charge of conducting any discount negotiations. And then, as we saw, it will make a recommendation in relation to a breach and the final fine amount to the Management Committee. So that's the first stage, the Oversight Committee. Now, when making a determination, what is considered? The determination process. First of all, the Oversight Committee, along with the Compliance Division, will consider whether there was sufficient evidence of a breach, whether a fine or any other enforcement action would be appropriate, and what the appropriate amount of any such fine would be. It's important to note here, if any other enforcement action is being considered, it may be submitted to the Management Committee along with the recommendation for the fine. So it's not limited to just a fine. And we said that for those fines greater than $500,000, it would go from the Management Committee to the Executive Committee. Now, the Management Committee has its usual members, but the head of the supervisory division, who's effectively in charge of the investigation or responsible for this breach investigation, shall not make any representations unless requested and won't be involved in the decision-making process. So we see that there are various checks and balances built in along the way. So if we go through these stages and there is a decision to issue a breach notice for one of these discretionary fines for a serious or very serious matters, what does that look like? So the breach notice will contain a statement notifying the person of the period to make any representations, and the period will not be shorter than 30 days. So there is time to make those representations. And remember, this is all before you get to court and before the final notice is issued. So if no such representations are received, the authority can consider the breach notice again, consider it to be undisputed, and may proceed to issue a fine notice. And note here as well that the breach notice or fine notice may refer to multiple breaches. If, however, representations are made, the Oversight Committee considers those representations. And you should note here that the breach notice itself will notify the affected party where this reply and these representations are to be sent. The communication will be conducted via email. So this is the breach notice, a period for response and consideration of that response. Once you've reached your final fine notice, that decision is final, and at that stage, the only way to appeal is through the court, which Mark will talk about. So we'll look at some of the considerations that are taken into account before we get to the breach notice or the final notice. And we spoke briefly last time about these principles. the principle of disgorgement. So making sure that you don't benefit from your breach. If there's been any profit, then that should be removed. Making sure there's a deterrent to prevent others, and making sure that there is the disciplinary principle where there is some form of punishment for the action that has caused the breach. And of course, CIMA is always mindful of the need to promote and maintain a sound financial system in the islands. Again, as well as these overriding umbrella principles, there are specific principles laid out which CIMA will consider. These principles include the nature and seriousness of the breach, whether it was done by intent or neglect, how long it lasted, whether any measures were in place to prevent it occurring, whether there was any intent to conceal the breach, whether any financial or other damage was caused, and again, the previous history of compliance, including any previous fine. So how is the amount calculated? Again, the disgorgement principle must be taken into account because the authority wishes to ensure that there is no profit from the breach. The seriousness of the breach will be considered and any mitigating or aggravating factors. An adjustment for deterrence and an adjustment for any discount agreement that we'll talk about. There is an exception for serious financial hardship. It is quite a high bar, especially for individuals. There are amounts that are noted, which if you would go below that amount, that would be considered serious financial hardship. And then for companies, considerations such as whether it would cause the entity to become insolvent. Now, looking at the early settlement and the discount principle. Where an early settlement is agreed upon, there may be a discount, and this could be up to a maximum of 40%. Now, this discount will not apply to disgorgement, so you still can't benefit from the breach. If such a settlement is agreed, the authority and the person enter into a discount agreement. This is where there's a formal written request from the affected party. The authority will expect that the breach is admitted and that any mitigation is submitted. And this will, of course, include matters we discussed before, such as remediation. CIMA may then request further relevant information, and there may be a settlement meeting. The proposed discount agreement is signed at the meeting and accepted by the affected party. On CIMA's side, it goes to the Oversight Committee and forwarded to the Management Committee or Executive Committee as applicable. And if agreed, that fully executed discount agreement is binding on the authority and the person. And we can see how significant this cooperation and settlement can be in terms of the fine amount, because it's actually laid out in the procedure itself. So you can see that where a party admits the breach itself and brings it to the attention of the authority itself, then the maximum penalty of 40% is applicable, and this decreases depending on the stage at which the settlement is reached up to the date of the fine notice. So just prior to the fine notice would be down to 10%. Now, we said how important remediation is, Kimberly, and I think it's really important to note here, this is both remediation of the particular breach in question, as well as wider remediation. How are you going to ensure that this never happens again? Of course, you'll want to do that for your own entity in any event, but it will also be, as we've seen, important mitigation to be taken into account by CIMA. Some other wider considerations and consequences. Publication, which we touched upon last week. Is this a matter that will be published? And this will be one of the factors to consider when considering, as you will, the impact on reputation, the effect on any group of which the affected entity is part, And of course, the financial consequences in terms of the fines, which may be significant. And Mark will talk about one particular one. And we mentioned last time future declarations. So when you are asked, for example, have you been subject to regulatory enforcement action? Finally, before I pass over to Mark, I'll just mention quickly the other topic that we discussed last time, which is the criminal prosecution of offences. In fact, the enforcement manual itself lists one of its enforcement toolkit options as prosecution. And you can see here on the next slide, it talks about the purpose of this, the criteria, and the implementation. So CIMA notes particularly those that are not properly licensed or registered, and also those who are not, again, submitting in a timely manner to CIMA when requested or required to do so. In cases where this is deemed to be the appropriate option, a recommendation is made to the Director of Public Prosecutions, and they will then consider independently whether the evidential and public interest tests are met. And just to remind ourselves that this could occur for those regulatory breaches, as you see here in the CIMA toolkit for breaches of the AMLRs, but also it could be in cases such as section 136 that we looked at, failure to file a SAR. That's on the next slide. That is a matter which can only be dealt with criminally, as is tipping off under section 139. That's a criminal offence. So in those circumstances, you would expect to see an investigation by the police. The police would pass a file to the DPP. The DPP would make a charging decision, and if there was a decision to prosecute, the matter would go to court. So that deals with all the pre-court matters, and I will hand over to Mark to talk about court applications in the case of regulatory enforcement action.
Great. Thank you, Elizabeth. And I do think we have another poll question at this point, too. Tom, if you can launch poll number 3. And it is asking, are you aware of any recent regulatory court proceedings in the Cayman Islands or your jurisdiction? And lots of responses already here. Yep, we have, I'll just give everybody a chance. Is there anything major going on right now in Cayman, Elizabeth, that you're watching?
No, not that we're aware of before the courts.
Okay.
Mark's going to talk about one matter before the courts, but otherwise, no.
Okay, great. So we have just about 20% saying that yes, they are aware, whether they actively follow or just aware of some recent cases. And 20% saying they're firm monitors, but they don't. And 50% are saying that they're not aware of any. Yeah, I'm not aware of any myself either. Okay, we can share that result and let Mark kick off. Thank you, Tom.
Thanks, Liz and Kimberly. I'm now going to take us through what happens when all the remediation and preliminary steps that Liz has just discussed don't work for you, and your only option left is to go to court and try and have the decision overturned. And there's 2 avenues by which you can do that. The first is pursuant to a statutory right of appeal under one of the relevant regulatory laws. All the regulatory laws contain a right of appeal to some extent. We've, sorry, I was going to say if we could go back one slide, if that's okay. Because we've set out on the slides the main rights of appeal that you're likely to encounter in practice. There are other regulatory laws, but I think these are the ones that you're probably likely to come across. And then the other avenue by which you can do it is via an application for judicial review. And this is sort of a catch-all remedy that applies when you don't have a statutory right of appeal. And it is important to get the interaction between the two correct. And the first point to note is that the remedies are mutually exclusive. So if you have a statutory right of appeal, you have to pursue that. You don't have an option to elect to pursue either your right of appeal or a judicial review. you have to take your right of appeal. And then similarly, if you don't have a statutory right of appeal, there's no mechanism for you to file an appeal, and you're left with filing a judicial review. And it is important to get the distinction, to choose the right process, because if you don't, what happens is you'd be at risk of having your proceeding struck out for having commenced the wrong proceeding. And if that decision's not made until after the deadline or the limitation period for commencing your action, you may be left without a remedy. And as we'll see, the limitation periods for both are quite short. So it is important that you get them right. And then also there can be some interaction between the two. If, for example, some of the decisions you want to appeal, or some of the actions or enforcement things that have been taken in the decision notice have a statutory right of appeal, and in other instances they don't. So then you may be looking at commencing a judicial review and an appeal. Also, there may be multiple decision notices issued within a same broader matter. For example, the entity may be subject to one decision notice, which does have a right of appeal, whereas the directors of that entity may receive a separate decision notice, which is subject to judicial review. And so then in those cases, you'd have to commence separate proceedings, but you might want to have them case managed together. And then just the last point to mention on this is Regulation 19 of the Monetary Authority Administrative Fines Regulation. And it's worth mentioning that because what that does is that gives you a statutory right of appeal, which is in effect a judicial review. So technically it's a right of appeal, but it functions for all intents and purposes as a judicial review, and the judicial review standards apply. So that's just one to keep an eye for. So when you are looking at commencing court proceedings, the first thing that you need to do is to check whether the decision that you want to challenge is subject to a statutory right of appeal. And although every regulatory law contains a right of appeal, you can't appeal everything that's in the regulatory law. So there are some actions that CIMA might be able to take under one of the regulatory laws that aren't subject to the statutory right of appeal. And just by way of example, to contrast to, under Section 34 of the Insurance Act, any decision of the authority other than a winding up petition or the appointment of a receiver or controller can be appealed. And so that basically covers anything, because a winding up petition is going to proceed in court anyway. So you'll have your right to make representations in court if you want. So that's a very broad right of appeal. Conversely, if you look at, say, Section 36 of the Mutual Funds Act, that really only gives you a right of appeal if CIMA have revoked the fund's license under one of the sections identified on the slide. So that means that other things that CIMA can do under the Act, such as impose conditions on the fund, require the substitution of any one of the promoters or operators of the fund, appoint someone to advise the fund, or even appoint someone to control the fund. All of those don't fall within the statutory right of appeal, or the scope of the appeal, right? So what you're looking at in those situations is that you would need to bring a judicial review to challenge any decision of that nature. Once you've established that you are within the right, you have a statutory appeal right and you're within the scope of it, you're then looking at Order 55 of the Grand Court Rules, which governs the procedure by how you bring such an appeal. I don't plan to go through the whole of Order 55 in detail, but I'll just highlight some of the key features that you'll want to know about. The first is that the motion is commenced by way of notice of originating motion. And this is a fairly simple document compared to, say, for example, a writ or a statement of claim. It really just sets out the decision that you want to appeal and the grounds on which the decision is being appealed at a fairly high level. And you do have opportunity to amend your notice of motion after it's been filed. So that's how you commence the proceedings. An important point to note is that you have 28 days from the date of the decision to commence the appeal. And that's technically from the date the decision is made, so the date of the decision notice or the fine notice, as opposed to the date on which it is served on you. But generally, those two dates will be quite close together. Once you have commenced your appeal, you then have to serve it on CIMA and any other person who's directly affected by the appeal. And then after that, it's the court won't, once you've served it, the court won't then hear a hearing of the appeal for 21 days after service. Now, in reality, that period will be much longer than 21 days, because often what you'll have is interlocutory skirmishes if directions can't be agreed. There may need to be discovery of getting certain documents in. You may need to put further evidence in. There'll be provision for skeleton arguments and written submissions to go in. And all of that generally pushes the timeline out well past the 21 days. So that's usually not a concern. The last two bullet points are quite important ones. Oh, sorry, if we could go back again. Or forward, I think. Yeah, back again, sorry. And the last two bullet points on that, the last two sub bullet points are quite important. The first is that the appeal is by way of a rehearing. So what that means is that on an appeal, what the court is doing is it's considering the decision afresh. So it can receive fresh evidence that wasn't before SEMA on the issue, and it can essentially step into the shoes of SEMA and replace SEMA's decision with a decision that it considers should have been made. So that's, as will come on when we look at judicial review, that's different from what the courts do, the exercise that the court undertakes in a judicial review. The other important point to note is that the appeal doesn't operate as a stay of the decision. And so what happens when you file an appeal is that SEMA's decision continues, like usually you'll have a timeline anywhere from 3 months, 6 months, 9 months, up to a year I've seen in the decisions. So when you get that decision, that timeline will be ticking, notwithstanding the fact that you filed an appeal. And generally the court proceedings will take longer to play out than the decision, or what will happen is you'll eat up a lot of the period in which SEMA has given you to implement the decision, progressing the appeal. So it's quite often that you need to get a stay of the decision. And the way you do that is, in the first instance, you either seek a stay from SEMA to see if they'll agree with it. If not, the court has provision to order it. So you'll have to want to consider that. And we'll look at that. Wow. The other thing, last bullet point on the previous slide, is that Order 55 is subject to any specific rules or requirements that are contained in the regulatory laws themselves. And there's only really two that we need to worry about for that. And the first is that most of the regulatory laws only allow 21 days to bring an appeal as opposed to the 28. So they've shortened the period for bringing an appeal by 1 week. And there is provision to extend that, which we'll come on to later as well. And then the other important point to note is that Regulation 20 of the Administrative Fines Regulations actually displaces Order 55 in favor of Order 53, which is the relevant rule governing how judicial reviews are brought. And it also applies the Judicial Review Practice Direction. So you remember I said that although it's technically a statutory right of appeal, it's in substance a judicial review. And so that's just one step further in that you actually have to pursue the procedure for a judicial review as opposed to the procedure for bringing an appeal. Most statutory appeals are commenced in the Financial Services Division. There's a specific provision of the Grand Court rules that says that any proceeding under the regulatory laws has to be commenced in the Financial Services Division. It's not critical if you get that wrong, because the court does have power and will transfer a proceeding to the Financial Services Division that hasn't been correctly commenced there. So that's not really something you need to worry too much about. Not a whole lot to say about the Financial Services Division, save that it's a division of the court that is manned by specialist commercial judges. When you commence a proceeding, it'll be assigned to a single judge, so they'll have carriage of the matter from start to finish, which can be quite helpful. And they generally do have specialist commercial knowledge that's relevant to a lot of the entities that will be facing actions. There's an FSD guide that applies that kind of sets out it does set out the procedure to be followed in respect to proceedings and interlocutory applications, just something to be aware of. And then perhaps one of the more interesting points is that any proceedings that are commenced in the FST incur a filing fee of $5,000 as opposed to the much lower $200 fee that applies to regular civil proceedings. So you've got to pay a bit more to commence a regulatory appeal. As I mentioned before, the appeal is by way of rehearing, and the court has power on an appeal to make any decision or order which it thinks ought to have been made. And it also has the power, if it doesn't want to do that, to remit the matter back to SEMA with its opinion or some directions for SEMA to consider when reconsidering the matter. So that takes you up to the hearing and the decision of the court. If you're still unhappy with the decision of the court at first instance, you can appeal the matter further to the Court of Appeal and ultimately up to the Privy Council. You'll need leave of appeal to do so, and the test for getting leave is essentially whether there's a reasonable prospect of success. And all that really means is that your appeal, like the prospects of success, are more than fanciful. So it's not the highest threshold to get over, but it is a threshold that you need to be aware of. Turning to judicial reviews now. These aren't something that are specific to regulatory proceedings. This is just a general jurisdiction of the court that dates back to the origins of the rule of law. And basically what it is it's a way to constrain and control government power to prevent abuses. And so what it is the court can review any exercise of power by a government authority to make sure it's within the scope of its power, basically to make sure that it's illegal. And SEMA is a public body for the purposes of judicial review. It derives its powers from statute and it exercises governmental power. So that's how you fall within the general catch-all if you don't have a specific right of appeal. Unlike a statutory appeal, the orders that the court can make are limited under a judicial review. And these are mandatory orders that require a party to do something, prohibitory orders that prohibit a party from doing something. And the one you'll encounter most regularly on a judicial review is a quashing order. So basically what a party will generally seek is that SEMA's made a decision, they think it's unlawful, and they want the decision to be quashed. So it's essentially of no effect. Sometimes that will often be coupled with a quashing decision and then an order to remit the decision back to SEMA so they can reconsider the matter in light of the court's guidance. As I mentioned or alluded to before, it's a remedy of last resort. So you have to exhaust all appeal or challenge avenues before you can bring it. So if you do have a right for SEMA to reconsider a decision, you have to exercise that right before you can commence your judicial review. Once you've satisfied yourself that you do have a right to bring a judicial review and you've exhausted all final remedies, the procedure for doing so is governed by Order 53 of the Grand Court, so 2 rules ahead of the one governing statutory appeals, and also has a practice direction that applies. And the practice direction is significant because it imposes requirements in respect of judicial review that don't otherwise apply to ordinary civil or commercial litigation. And those requirements are, firstly, that the parties consider whether the dispute can be resolved by alternative dispute resolution, so some form of negotiation, possibly mediation. And that is a mandatory requirement. But the requirement is only to consider mediation. You don't actually have to, it's not a requirement to undertake, not mediation, ADR. So it's a requirement to consider ADR. You don't actually have to undertake ADR if you determine that it's not suitable. The second requirement that's imposed, which again doesn't apply to ordinary civil litigation, is the requirement for the parties to engage in pre-action correspondence. So the plaintiff has to send a letter to SEMA setting out its case, saying why it thinks SEMA's made a mistake and the grounds on which it'll be challenged. SEMA will then have 21 days to respond, to set out its response, saying either, okay, it agrees with the submissions, or actually, no, we think we got it right and we're happy to challenge this judicial review if you bring it. Non-compliance with the with the practice direction is something that the court can take into consideration when determining whether to grant leave. So it is important that you do comply with the practice direction, or you have a good reason for not complying with the practice direction. And the practice direction actually contemplates and states that it won't be appropriate in urgent matters. So if time is of the essence, which is something we'll look at shortly, you can dispense with the practice direction and just file your application for leave to commence judicial review. Order 53, again, I won't take you through the whole of Order 53, and I'll just highlight the salient features that you want to know about. The first, and probably the most important, the first, I'd say jointly most important, is that you need leave of the court to commence judicial review proceedings. You can't just go off to the court registry and file your application for judicial review. What you have to do is take the preliminary step of asking the court for permission. And basically, this is a mechanism that lets the court scrutinize whether there's any merit in the application, so it doesn't waste its time dealing with frivolous applications, which you can often get in relation to public administrative matters. That application is generally made ex parte on the paper, so that means you don't have SEMA won't show up and be heard. There's not an oral hearing, and SEMA won't make representations. If the application is dismissed, you do have a right to request an oral hearing where you can go before the judge and try and convince him that he's got it wrong and he should have leave. The test for granting leave is similar to that for the test for leave to appeal, and that's basically that there's no reasonable prospect of success. The other thing, I'll speed up a little bit now because I'm conscious we're coming to the end of the hour. You have a longer time period for commencing a judicial review than you do a statutory appeal. There's a long stop date of 3 months. The primary obligation is that you need to commence the proceedings promptly, which can be much shorter than 3 months, but there is a long stop date of 3 months, which again can be extended. Generally speaking, with both judicial reviews and appeals, the court expects matters to be progressed quickly. There's a recent Court of Appeal decision that endorses a statement of the Grand Court that says they expect judicial review proceedings from start to finish to be concluded within 6 months, which is much quicker than you'll get for most ordinary civil or commercial litigation, which generally plays out over a period of years. This is an important point that I'll run through quickly, is the standard to be met for a judicial review. And this, what happens on a judicial review is, it's as the name suggests, the court's not making a decision fresh. It's reviewing the decision that SEMA made. And this really arises out of the nature of the judicial review. And the fact is that it's there to control misuses of public power. And so the court's not trying to substitute its decision. Oh, I think I would have done it differently than SEMA, and so I can do that. It's really trying to determine whether SEMA or the public body in question has misstepped when they made its decision. And there's 3 primary grounds in which you can do that. The first is illegality, which basically means that the court or the public body broke the law when they made the decision. The primary basis for that, the main basis, is that the decision was ultra vires. It was outside of the judicial body's statutory power. So in the case of SEMA, they've done something that they're not authorized to do under the regulatory laws. Other grounds for establishing illegality are that the decision was made for an improper purpose. So if the decision was conferred, like if the power was granted for one reason, but it's been exercised for a different reason, that'll found the claim a basis for illegality. Another one is the decision's been improperly delegated. So if SEMA or a certain organ within SEMA is responsible for for making a decision, that decision can't be delegated to someone else to take. And then the last relevant ground I discuss is whether the exercise of discretion has been improperly done. So that involves situations where SEMA would have considered a factor that's not relevant in making its decision, or it would have failed to consider a relevant factor. Any of those will found the basis of a claim for illegality. Unreasonableness and rationality, that's a bit of a higher threshold, and it's quite difficult to succeed on that. That's basically one where where the court will say, okay, the public body who's made the decision was so unreasonable that no rational person could have made that decision. And the reason, which is quite a high threshold, and the reason that threshold is so high is because the court doesn't want, in conducting the review process, the court doesn't want to trespass on the public authority's decision-making power and substitute its own decision. So it's quite difficult to succeed on that. And then the final one is procedural fairness, which basically means that the procedure by which the decision was made violated the principles of natural justice. And the two things to consider there are whether there was any bias in the decision-making process. Generally, you'll be considering apparent bias as opposed to actual bias. And that's just basically when a reasonable observer would have looked at the situation and thought that it may have been biased, as opposed to actually having to prove that there was in fact bias. And then the other one is a right to be heard. So basically, they can't make a decision without giving you an opportunity to present your case or make representation. So if either one of those is apparent, that may be a basis for setting it aside. And then an adjunct of that is legitimate expectations. So if in making a decision, a legitimate expectation has been breached, you can seek recourse for that. Legitimate expectations generally arise through some form of representation or habitual practice. So in guidance notes or communication from SEMA, or if there's something that they do regularly that they've not done in your case. Proportionality generally isn't a basis for review, although it is a basis under Regulation 19 of the Administrative Fines Act. So that, although it's the Regulation 19 appeal is in substance a judicial review, it's slightly tweaked to include this extra ground of challenge. Again, you can appeal if you're unhappy with the decision of the Grand Court. You can appeal that to the Court of Appeal or the Privy Council if leave is granted. And then lastly, there's some other issues to consider when you are bringing these applications. The first, as I mentioned before, is that the statutory appeal or a judicial review doesn't act as a stay of the decision, so you'll probably need to get a stay of the decision. The first protocol is to see if SEMA will agree to stay the decision pending the appeal. If they won't, you can then apply to court in terms of a statutory appeal to have it stayed. The court has express power to do so. It doesn't have express power in respect of judicial reviews, but how they operate is once leave is granted, it will then be a stay will then be imposed. So the filing of a leave application doesn't impose a stay, but the granting of one does. So that may be a factor to consider when you're looking at how long you're going to take to file your leave for judicial review application. If the matter's urgent, you may want to get it. If you need to stay urgently, you may want to get your application in urgently so that the application is determined urgently. You may want to apply to extend time for commencing a statutory appeal or judicial review. It's going to be less likely in respect of a judicial review given the 3-month period. There is power for the court to extend an appeal for the period for filing a leave application. If there's good reason, but what you'll generally find difficult is establishing good reason, being you've got a long stop date of 3 months. Where this is more relevant is in respect of a statutory appeal, which is either 21 or 28 days. And there's 2 ways by which you can apply for an appeal. Before the expiry, before the deadline of the expiry, notwithstanding you haven't commenced the proceedings yet, there's a mechanism for that, and which is what we highly recommend. Or you can, if you've allowed the deadline to pass and you still haven't commenced your appeal, you can seek a retrospective extension. The risk with that, though, is if you don't get your extension, then you'll be time barred from bringing an appeal. Whereas if you apply and have the application determined before the limitation period expires, if your extension application is refused, you can still then rush to get in an appeal to start, to get a protective appeal in. And you can always amend it later if you need to. Confidentiality and anonymization. This is something that clients are often concerned with because they want to protect reputational harm. It is possible to get confidentiality or anonymization orders, but they are very difficult to get. That's the case in respect of litigation generally, but the principle applies even, or the difficulty applies even more so in respect of public proceedings, because there's a heightened public interest in the proceedings. So you can get them, but they are difficult. There is precedent that, and this happened in the Maples case, was that you can get a confidentiality order over the leave to appeal application up to the point the leave to appeal application is determined. Once the leave to appeal application is determined, it seems that it'll be very difficult to maintain confidentiality. Anonymization is generally easier to get because that's not a complete blanket. You're not completely keeping the proceedings out of the public eye. All you're really doing is withholding the identity of the party to the proceeding. So they're generally easier to get. And the proceedings that are ongoing now that Liz mentioned earlier are subject to an anonymization order. Costs, something to be aware about. Litigation in general, but particularly in the Cayman Islands, is very expensive. So if you do file an appeal, you're at risk of you'll have to fund your own party's costs up front, and you are also at risk of having to pay CIMA's adverse costs if you lose. So the general cost rule is that costs follow the event. So the converse of that is if you win, CIMA will have to pay your costs. And then one thing always to keep in mind when you're going through this is whether it'll be possible to settle the matter. It is possible. The matters have settled with CIMA, and you can, I think, if you can save yourself a lot of time and expense if there is a middle ground or some form of settlement fee, because the litigation is time consuming and quite costly. So it's just always something to keep in mind when you are going through this. And then the last thing, which I won't go into detail because I see that we're now over time, is that we've just put up some examples of the recent examples of appeals and judicial reviews that have been taken in the last couple of years. And probably the most prominent two that you'll be aware of are the Maples appeal and the Intertrust litigation. The last one that ABC versus CIMA is the one that Liz mentioned. That's currently going through the courts. There was a Court of Appeal decision in April by which CIMA was granted an extension for filing their evidence. So that one, I imagine CIMA is in the process of filing its evidence, and we'll just have to keep an eye on that to see if there are any more public judgments that come out on it. I hope that's helpful, and I'll just hand back over to Liz to wrap things up.
I thought that was very helpful. Mark, thank you so much. I do realize we are over time. I'm happy to stay on for another 10 minutes. We still have a pretty good crowd listening in. So if you can stay on, I'm sure there will probably be some questions. Liz, are you able to stay on? Sorry, I'm not hearing you, Liz, if you're muted.
Can you hear me now, Kimberly?
Yeah, I can hear you now.
Yeah, of course, that's fine. I'll just quickly wrap up with the conclusion and then we can see if there's any questions.
Okay, great.
One matter that we didn't mention that we will mention now is, you will have seen as we've gone through particularly the court proceedings, but from the earliest stage in terms of these representations, it is important to consider instructing counsel. As Mark said, time is of the essence. There are tight deadlines. We looked at the fact that criminal or administrative penalties may be imposed depending on the breach and depending on the legislation under which it's under. We saw section 136, failing to file a SAR is criminal, and we saw for the AML regulations it could be dealt with by fine or criminally, and we also saw the other enforcement actions available. We noted that criminal matters are investigated by the police and passed to the DPP for a charging decision. We noted that fines that are imposed by CIMA are subject to appeal, but that the appeal is by way of judicial review. And we considered some other actions that can be taken prior to or instead of court proceedings, with a particular emphasis on remediation, mitigation, and also considering publicity and other consequential effects. And then Mark spoke about the court proceedings, if you reach that stage, and considering whether these will be by way of statutory appeal or judicial review, and some of the procedures and considerations to take into account there. So I hope that was a helpful whirlwind tour, Kimberly. And thank you very much again for having us.
Yeah, thank you very much. And this is kind of interesting for me to kind of just remind our audience, especially the managing directors, the executives. These are some of the decisions you're going to have to make if you do find yourself in breach, and the processes and the court costs and the time it's going to take. I'm sure it just consumes energy and mental energy and financial resources when you do get to this stage. Um, but at the same time too, sometimes you have to do it. So thank you very, very much, Elizabeth and Mark. I don't see any questions. Please do post any questions or give us a thumbs up or a thank you in the question box if you don't have any questions. It was so detailed. I really appreciate your time. And again, I want to remind our audience that we don't pay Elizabeth and Mark. They don't pay us, so this is their free time that they are giving to us to help the AML professionals, and we really do appreciate you guys for your time and your expertise and your knowledge and sharing it with us. So
Well, thanks so much, Kimberly. Thank you for having us, and thank you for the service you provide to everyone in offering the webinar and the ability to share the information and hopefully help other people and see if we can help people to understand the procedure and make it more accessible.
absolutely, and this is very much, as I say, a passion project of mine to keep this free. So I do encourage everybody to share the webinar with your peers and at the compliance associations. Sorry, I'm trying to get to the next slide because I know you've got a training coming up next week. Elizabeth, is that correct? And do you still have any room left? Because it's live and in person,
Yes,
correct?
it's live and it's in person and it's in Georgetown Yacht Club, and we have a few spaces left. So please contact us if you would like to join us on the 13th of May. The focus is on the requirements of AML officers, but it will be interesting and helpful for anyone who's involved compliance below the compliance officers or even above, such as directors who want to be more aware of the requirements and responsibilities.
Okay, great. So you have a few seats left, and that is next week. So please do. You can reach out to Karina at there's her email there for those of you who are interested in that. And I have put your website on our follow-up email. So remember, you will get a certificate of attendance today. And I'm getting a lot of thank yous and very informative and insightful information. Like I said, that was very, very detailed. Again, thank you both very, very much. For those of you who are not in Cayman as well, I am giving a training session next week virtually for those who can't attend live training. So if you are trying to find some kind of AML awareness training, you can join us next week. So you can reach out to Tom Gardner on our, there's his email there. Sorry, I realize we're well past the hour and I know everybody's busy and probably ready for lunch by now. So I want to say thank you again for joining us. And thank you again, Elizabeth and Mark. And thank you to our audience for joining in and participating in polls. And I hope to see you all. And we do have some upcoming webinar topics. Please go to our website and you will see the upcoming topics for, I think, up to June. So thank you and have a great rest of your day.
Thanks so much, Kimberly.
Thank you.
Thanks,
Bye.
everyone.